SJC-13555, Bruce Johnson versus Caroline Settino.
Okay, Attorney Seiden, whenever you're ready.
Good morning, Your Honors. May it please the Court. My name is Stephanie Taverna-Sedin, and I represent the appellant, Bruce Johnson. I'm here today to ask the Court to do two things. First, reverse the trial court's opinion, or the decision, and find that Mr. Johnson was not at fault for terminating the engagement and award the engagement ring and wedding band back to Mr. Johnson. The second thing I'm here to ask the Court to do is, if the Court is inclined to change the law with respect to engagement rings in this state, then it should move Massachusetts to a no-fault conditional gift jurisdiction. We should move to a no-fault jurisdiction because moving to a no-fault state aligns with the Massachusetts divorce law, which was enacted in 1975, and where the public policy under that legislation was to take fault finding outside of the parties, away, so that parties could decouple without acrimony. The same reasons
Do you know the
apply
breakdown on the no fault versus fault? Did you do a 50-state survey? Do you have a sense of what the numbers, how it breaks down? How many states have moved to
Yes,
no
Your Honor.
fault?
The majority view in the United States is no-fault conditional gift rule. There is one state in the country, Montana, which follows the opposite view, which is a no-fault absolute gift rule, or inter vivos gift rule. So the modern view in the majority of states follow the no-fault conditional gift rule, and there are a few states, like Rhode Island, that haven't touched on the issue yet. I think there are about 3.
So our decision's written in 1959, so
Correct.
it's 65 years old at this point. So we're in a distinct minority at this point?
Exactly.
Counsel, could we go back to where you started? I think you mentioned 2 rings. Is it the wedding band that was intended for Ms. Settino that you're also looking to have returned?
Yes, Your Honor. And our position with that is that the engagement ring was not a complete gift under DiCicco because it was a conditional gift that the gift only completed upon the marriage happening. The wedding band didn't even get to that point of a conditional gift because it's intended to be given at the time of the wedding.
Let's go back to DiCicco for a second. I think if you read the appeals court dissent, I think one of the concerns that I have here is we've never really animated what the metric ought to be for fault. And your position is that there should be a justification kind of analysis where you look at the not just who actually pulled the lever, but factor in why. And in your case, you're saying, that Mr. Johnson there was a bunch of things that the trial judge did not essentially fully credit in making that determination.
Yes, Your Honor. So our position is that the trial court committed an error of law by failing to hold Mr. Johnson to the standard of proving fault. What the trial court held Mr. Johnson to was proving that Ms. Settino actually had a sexual affair. Mr. Johnson...
Well, that's your gloss on it, but the trial judge does talk about the fact that he credits Mr. Johnson in what he claims was the way he was treated prior to misconstruing, because that was a factual finding, the text messages. So I'm trying to figure out, how do we get to clear error where the trial judge is also sitting as the fact finder and has made factual determinations that, I give you that you didn't like that perhaps she said things to you that you didn't like, or that she called you a moron, or that she wasn't there for you when you were going through your cancer treatments, but you still call this off because you were wrong about the text messages. So he does take the full universe of what Mr. Johnson testifies to in assessing the fault analysis.
And that's why we argue that the court needs to imply a justification analysis in fault finding, because without a justification analysis, as the trial judge wrote, he found that Mr. Johnson must bear the fault. But if you look at the facts from an objectively reasonable perspective, Mr. Johnson did nothing wrong. There's no action on his part that could be objectively identified as fault.
Isn't the inquiry then whether or not the trial judge was clearly erroneous?
Exactly.
So why do we have to get into justification? Is it?
Well, because I think that the error, the evidence itself, the judge was clearly erroneous, but without the guidance to do a justification analysis, you're becoming it's almost like you're imposing a strict liability. The party that terminates the engagement is at fault.
It's an uphill battle for you on this issue because of the factual finding, the deference.
I'm sorry, Your Honor.
It's an uphill battle because of the deference we have to give to the trial judge, not one that the appeals court had a problem with. But
so my argument in that perspective, Your Honor, is that the deference has to be given for factual findings. And so if you accept the court's finding, which we disagree with, that the client, that Mr. Johnson made his decision to terminate the engagement solely or predominantly on the text message and his mistaken belief that appellee was having a sexual affair, even if you accept that is true, when you get to the application of those facts to the law, I would submit that fault finding is either a legal question because you're applying facts to the law, or a mixed question of fact finding and application of the law. And when you get to that point of taking that conclusion and applying it to the law, it's clearly erroneous because no objectively reasonable person could say this man was at fault for deciding not to marry a woman who he didn't trust.
We seem to look silly trying to do this, either under your justification or your fault analysis, because it's so indeterminate who's at fault for not going forward with the marriage, right? I mean, I just feel like you lose unless we move to a no fault, because, I mean, trial judges found this, and it's so open-ended that you can almost focus on anything.
I agree, Your Honor, and there's several cases that discuss that. Campbell versus Robinson in South Carolina, Hyman v. Parrish in Kansas, they discuss the trouble with fault finding and how amorphous it can be. And that's why the majority of states in this country have moved to a no fault.
But can I ask, if we move to a no fault, does that mean the person who gives the ring always gets it back? It's, again, if we don't do fault finding in divorces anymore. That statute that DeCicco interpreted also said we're not gonna get into who's to blame for, in other contexts besides the ring. We're not gonna have you able to sue over this. But I'm just trying to figure out the consequence. Who gets to keep the ring if we move to a no fault? Because the ring has been transferred in some respect.
Our position is that if we move to a no fault jurisdiction, the law of DeCicco, which says that it is the engagement ring is a conditional gift, should remain as a conditional gift, so that if the marriage does not happen, the purchaser of the ring gets the ring back.
Why?
It's most equitable, Your Honor.
Why?
Because the person that has spent money or value on the ring is doing so under the condition that I'm proposing to you, I'm expecting, we're going to get married and we're going to live a life together. If you change the gift to an inter vivos gift, that person that gave the ring loses the value of the ring if the marriage doesn't happen, and it becomes...
But if it was a tennis bracelet?
Yeah, or a car.
Yes.
I agree. I think all of those...
Why is it the ring?
Well, the ring has special value in our society. Traditionally...
But no one wants to keep the ring. I mean, the ring is no longer a symbol of love. It's a symbol of that the thing broke
Unless it's
down.
worth $70,000.
Exactly, and that's what Cooper v. Smith said. The
Then
ring,
it's cash. It's not that the ring has any value, it's that the ring is worth a certain amount of money.
and why should the person who was conditionally gifted that ring receive the value of the ring if the condition upon which the person received the ring doesn't happen?
Can I ask a question about exactly what you're saying vis-a-vis the factual findings here?
Sure.
So what the trial judge found was that the ring was given and the ring was received, and I think I'm quoting the judge here, in anticipation of marriage. What do you understand that factual finding to be? And specifically, do you understand the words in anticipation of marriage to be a factual finding that it was conditioned on the wedding going forward or not?
Yes, Your Honor. Under DeChico, the findings that the ring was given and accepted in anticipation of marriage can cause it to become a conditional gift.
So I understand how it makes DeChico apply, but my question is, if we have a question for whatever reason, however this all comes out, that we want to actually know whether Mr. Johnson gave this ring, and in his mind, and ideally also in her mind, they had a meeting of the minds that this was conditioned on the wedding going forward. Do we even have a factual finding right now on whether anyone thought that there was a condition?
Yes. So at trial, Ms. Settino argued that it was an inter vivos gift. She presented evidence of receipts that she had received for the engagement ring, in addition to several other gifts that Mr. Johnson had generously given Ms. Settino. And the court found that the engagement ring was not an inter vivos gift. The court found that it was a conditional gift or given in anticipation of marriage. And by the court's analysis, you can infer that the language anticipation of marriage, that he found that both parties gave and accepted the ring in anticipation of marriage, and his failure to find in appellee's view that it was an inter vivos gift, and then him getting to the application of DeChico and saying it was a conditional gift and he states the law. Our position is that the court found that it was a conditional gift.
I understand that's your legal conclusion, but I want to get an answer on the factual question. Do you think that the judge made a factual finding that Mr. Johnson gave the ring on condition that they actually get married?
Yes, it was implied. Mr. Johnson gave the ring at the time DeChico was a law of the land. There's no evidence in the record that his donative intent was other than giving a conditional gift that he proposed to her, and he didn't explicitly say, I'm giving you this ring on the condition that we'll be married. But case law addresses that issue, that at the point in time somebody is proposing to another person, they're so blissfully in their relationship, they're not thinking about, this may end badly. And they don't expressly state, this is the condition on which I'm giving you this gift. And that's why DeChico implied
That apply to the
it.
dental work too? The dent, because that's also done in anticipation of marriage, right?
Your Honor, we did not challenge after appeal.
The dental stuff any different than the ring? I'm trying to understand. Fixing her teeth is,
It was, the court found that it was a promissory estoppel, and we only challenged the prejudgment interest on that. We did not take the finding in that regard on appeal.
So the rule that you would like is that if it's a ring that's exchanged, that is a conditional gift.
Yes, and I think
Okay, but if it's a car that's exchanged, that's an inter vivos gift.
those situations you can get into the specific facts and circumstances, because that is not something that happens every day in everyday relationships before people get married. I think
well, they move in together and they buy furniture, and how does that all work?
I think you could use the same analysis, that if it's given in anticipation of marriage and the marriage doesn't happen, then yes. But that doesn't get us the efficiency.
But most, I've not seen any cases where the car is anything other than an inter vivos gift. Are you aware of that? I think there's a specific
I'm not
societal value on the ring, right? Or do these other states say that it could be whatever gift?
I'm not aware of any case that says that a car or a tennis bracelet were given in anticipation of marriage and that it gets, it's not a completed gift.
But as you know, usually in these situations, the dynamics are such that you don't say, I give you this car if you marry me.
But the difference is the ring has a special value. and
Right,
there's-
so you're arguing for a specific, to this particular type of gift, have this condition.
Yes, and I think it's most efficient for the law because engagement rings are something that happen very often. Many people give them, and it helps the judicial economy to say that in this specific circumstance, this is the rule. It's, no fault, donor gets the ring back. It's the most equitable, and it avoids litigation. These parties have been in litigation for 6 years, and their relationship was only a year and a half. So it's really something that the court does need to address, and I think the most equitable solution would be to find a no-fault conditional gift rule. I see that my time is up. If anybody has further questions, I'm happy to stay.
Keith, could I ask one question? Counsel, if we were to find that, though, how would it have retroactive applicability?
I don't think it should, Your Honor, beyond the.
So how would that help you if we were to find that?
Well, I guess I misspoke. I think retroactive applicability to a no-fault conditional gift rule is completely fair and perfectly appropriate because the no-fault part takes the litigation out for anybody that is breaking up and doesn't have to fight about fault. And the conditional gift rule
But
goes.
this would be a new rule, and typically when we announce new, because the Chico's a fault-based rule.
Right.
And you're advocating for a no-fault rule, so that would be a new rule. And rarely do we ever say that when we announce a new rule, it has retroactive application. So why would we do that, and why would it help you?
Well, I would say Commonwealth v. Hernandez would be a good guidepost to follow in that case. If you're willing to decide that it is a no-fault conditional gift rule, it should apply to the present case, if not retroactively, as the court did in Commonwealth versus Hernandez. It applied the new rule to the appellant that brought the case, but not retroactively beyond that. I have to say, though, if you are inclined to make it an outright gift and follow an inter vivos rule and do away with it being a conditional gift, then I think it would be patently unfair to change the law without an announcement that for anybody that gives an engagement ring going forward, you won't have the right to get it back if the engagement ends without your fault, because that's been the law in Massachusetts for 65 years. But I don't think the inequity goes the same way if you make it a conditional no-fault rule.
Is it an inequity or is it a due process issue?
It could be both, Your Honor. I definitely think it's an unjust, where you're relying on the law. Mr. Johnson gave the ring to Ms. Settino at a time when DeChico was the law, and it said, if it's a conditional gift, and if the donor, their marriage doesn't happen, the donor can get the ring back if he's without fault. To change that now and say it's going to be an inter vivos gift, and he wouldn't have a right to get the ring back, I think that would be unfair and unjust. Thank you, Your Honors.
Thank you. Attorney Rosenberg.
Good morning. May it please the court. Nick Rosenberg on behalf of the appellee, Caroline Settino. If this court is going to move to a new rule, I think there's little dispute that no fault is the modern trend. And the parties seem to agree that the court should not be delving into the fault or justification for the end of a relationship. Where there seems to be a dispute is this conditional gift issue. And there are three main problems with the conditional gift concept, and possibly others. One is, as we just discussed, it requires reading into a party's private act this societal idea of what their intent is when it's not expressed.
But didn't we already say it's a conditional gift, and isn't really the analysis about fault here?
But I think
Because
the conditional gift...
Didn't we say that in DeChico, that it's a conditional gift? And-
Absolutely.
Okay, so let's focus on the fault thing. The findings in the case are a little bit odd, because there's a continuum here. And I guess if we're going to be talking about the fault analysis and whether the trial judge was clearly erroneous in the fault analysis, he does credit that there was some mistreatment of Mr. Johnson that went into, that helped animate the decision to call this off, even though he made a factual finding that he was wrong about the text messages in the voicemail. How are we supposed to assess fault where it seems like the trial judge collapses it all into the text messages in the voicemail, where Mr. Johnson testifies about what he perceives as his mistreatment? He testifies about his deliberation of this, that it wasn't just on hearing the voicemail or seeing the text message. He took a couple weeks to really think about that. How are we supposed to assess it without being a justification analysis?
Yeah, I don't think the judge reduces it to just the text message. As you said, Justice George, he looked at the context, looked at the relationship, acknowledged that there were some potential name calling, there's some fights and disputes, but at the end of the day said that it was this rash decision to jump to the conclusion, you're having an affair, we're done, that was the he used the word predominant cause for the breakup. He looked at DeCicco, which was the prevailing rule at the time, and DeCicco said, if he's not without fault. And the judge looked at that and said, well, he jumped to this conclusion, so you're having an affair and was wrong and called it off. Neither of them at the time otherwise wanted to break off the relationship, and that's a factual finding, and therefore he was not without fault. He had some fault. Under DeCicco, he didn't have to find...
But doesn't that obviate all of the other testimony about what he said about how he was treated? Let me give you a really poor example that might make this a little bit more simple as to what my problem is here. Let's say that your partner lies to you 1,000 times. 999 of those times, they actually lied to you. But the 1,000th time was they actually didn't lie to you, that it was actually the truth. So the way, by analog, the trial judge here seems to say, yeah, I credit all of these things that you're saying about how you feel she mistreated you, the way she called you names, that she blamed you for things that went wrong. But this one time, when you thought she was cheating on you and you mistook this text message or this voicemail, that is the sine qua non to the fault analysis. And the other 999 times where she lied to you is a nullity. It means nothing.
To be candid, I think if you look at what Judge Glenning was doing, I think he sort of did a justification analysis.
I think he did a little bit of it.
I think he did, because I think he looks at these things and said it wasn't reasonable. It wasn't justified in breaking this off. You know, maybe Judge Glenning was thinking, normally, if you found these texts, you might say, hey, what is this? Let's talk about it. And then when the partner says it's nothing, he and his wife were invited to the wedding.
That's exactly.
Right?
That's
he
it
and the wife were
exactly.
invited to the wedding.
Because that was informed by the stuff that happened before.
But Johnson didn't do that. He jumped to the conclusion and said, I'm out of here. So he's not without fault. And I think, to your point, maybe on the same page.
I mean, it seems to me that this discussion is a CEG as to why we have to move to the no fault.
Precisely.
Exactly
So
right.
you started your argument with the 3 reasons why conditional gift no fault is not good, and I've now lost track of the first one. What were the 3?
Thank you, Joseph, for bringing me back to that. The first is that it requires the court reading into a private act this condition that's not there. I think what came out of the discussion earlier was that I think it was even conceded that Johnson may not have intended that condition. And certainly Ms. Settino, who said, I got these receipts, he gave me this ring, the receipts are so that I can go return it.
I mean, it may be silly, but he clearly gave her the engagement ring because he thought they were going to get married.
Absolutely, in anticipation they'd get married.
I mean, what are we reading in?
Right.
Yeah, so
anticipating we'll get married is different than I'm giving you this thing of value.
Right.
It's a gift. I feel good enough about this relationship, and I'm confident that we're going to be together. So I'm willing to part with something of value and give it to you.
Is that what the law? Could you explain what the modern rule is and how it works? Because this old rule seems old-fashioned and kind of silly. So what is the modern rule, and how does it
The modern rule of conditional gifts or the modern rule of
Forget about
engagement
conditional
rings in
gifts. The
particular?
modern rule for dealing with engagement rings out there, is it what? And how do
So-
they,
So
the no-fault modern rule, how does it work?
the models out there are that there is no fault, that
Right.
if there's a ring given and a couple breaks up,
Right.
either the ring goes back, and some states might say unless there's outright fraud, the ring goes back, or in Montana, in the Albinger case, a gift is a gift, the ring stays.
So what is, the majority rule does what with the ring? If we move to a no-fault
It goes
system,
back to the
More,
donor.
more states say the ring goes back.
and why do they do
Because
that?
they maintain this concept of the conditional gift. And if I can address that point, and this is important, one of the ways that the plaintiff tries to distinguish what Montana did in Albinger is to say, well, Montana doesn't recognize a conditional gift. Conditional gifts are normal in Massachusetts, and they cite the Maffei case. That's simply not true. A conditional gift is a legal fiction created to get around the Thibault decision and allow the man in DeChico to get the ring back. We don't have conditional gifts in Massachusetts. The Maffei case was a charitable donation to a church, and the analysis there was whether or not that was held in trust or a constructive trust to be used for church purposes. The mention of a conditional gift in the Maffei case, the court actually put in quotes because it didn't acknowledge that it's actually a thing. So the notion that, well, we have conditional gifts,
So
and we are
I'm
able
trying
to
to-
imply conditions, so this is,
Trying to understand what because you're representing the person who got the ring, and you obviously don't want it returned, but you're also in favor of the modern rule. How do we rule in your favor if we move to the modern rule? And let me add one last question to that, because I'm not sure I understand the retroactivity point. I understand when we change and interpret. I just don't know how that works in a common law case like this.
So I think, a few things. First, I think that if it's not retroactive, then obviously we feel that the findings of the trial judge are well developed. 4 days of trial, 7 witnesses, a few dozen exhibits, and I think it was addressed. I didn't address it when I came out because I think it was addressed earlier that this court will be loath to upset the findings of the trial judge. There are a few ways this could go. I agree, Justice George, and I think my sister, that a change in the fundamental rule from a fault-based to a no-fault is a new rule that should not be retroactive. There is one way in which I could foresee this being retroactive, which is an interpretation of a statute that was always the way the statute should have been interpreted, sometimes may be retroactive. And here you might look at the
With statutes, we say the exact opposite, which is it's not, it is. It's as if we always interpreted the statute that way. So with a statute, it's the opposite rule applies. It applies to the parties in the case.
Right. And what I'm saying is if you looked at the Hartbaum Act and said it never carved out conditional gifts or rings. The Hartbaum Act was the Hartbaum Act from the day it was enacted that said you cannot bring a case to right or wrong for breaching a promise to marry. So I think so.
Did Chico carve the ring out of that statute, right?
Right. And if this court said Hartbaum Act never carved that out, never should have carved it out, maybe that's retroactive. But I think if you change the law from a fault-based to a no-fault, that is a significant change. But I do want to go to the other reason why, if I've answered the question, thank you. The other reason why the conditional gift rule is problematic is, of course, because of the Hartbaum Act and Chapter 207, Section 47A. And Johnson, the cases cited in their brief, stand for the proposition that the societal norms hold that the engagement ring is symbolic of this pledge, this promise to marry, that implies that condition into it, even though it's not expressed by the parties, and if that condition is breached, the ring then goes back. The elephant in the room is what's this condition that's being read into it? And it's that someone is going to marry you. And the statute of Massachusetts, Section 47A of Chapter 207 says, a breach of a contract to marry shall not constitute an injury or wrong recognized by law, and no action, suit, or proceeding shall be maintained therefore. It means that there is no wrong in deciding not to get married.
I'm still struggling with why we're talking about this, because DeChico said we're going to carve out the engagement ring about it. So we have to talk about the conditional gift, even in light of the heart bomb statute, don't we?
I think we have to recognize that at the starting point, an inter vivos gift is a gift. It is complete on transfer. If you have the intent and you transfer it and it's accepted, that is a gift. There is no such thing other than DeChico's creation of this ring in limbo. That, you know, the one with the diamond ring, it's an option
So
on the marriage.
Are you contending that that a person literally cannot achieve a conditional gift? Like I'm going to say to my child, you know, I'm going to give you $20 to spend at the candy store this evening. I'm giving it to you right now at 9 a.m. And I want to make this really real to you. You are going to be really obedient for the next 9 hours while we do a painful task, and then you'll go to the candy store. And then she is not obedient. I take away the $20. I'm choosing a really simplistic analysis, but like, Isn't it possible to achieve a conditional gift in reality?
To be completely honest, I thought the same thing as I got into this case. I thought we talk about it all the time.
But not
charitable
for,
gifts,
but
other
not
things.
for marriage.
But not for anything. That's a remedy. You as a parent have the right to take something away from your child, the money, but it's a gift. When we talk about charitable gifts and you give to a museum and you say, well, you didn't use it to buy art and I want it back. Those are trusts. You can establish a trust. A gift is you're transferring title of property, ownership. And the ring is either yours or it's mine. There is no such thing as this, it's yours for now, but then I'm going to bring an action to take it back. One, because in terms of strict property and gift law, there's no such thing in Massachusetts. And two, because under the statute, you can't sue to get it back.
We've said that marriage, like we don't enforce, you know, marriage broker contracts. We don't impose fault in divorce. We've said we don't want to encourage bad engagements. Or bad marriages. We want to stay out of that business, right? So conditional gifts can be fine, but not conditioned on marriage, right? That was probably the error in DeChico.
There may be other areas where if the legislators thought that we should have conditional gifts or, you know, trust law develops, perhaps. My point is just that the argument that, it's just another conditional gift and we have those a lot is just simply not the case.
In fact, the
in
default is inter vivos gifts.
I'm sorry, what's that?
The default is inter vivos
Yeah,
gifts.
the default is that if you say, this is of value and I want to give it to you because I think we'll be together forever, if you're wrong, you're wrong. That's a different problem. It's, I give it to you, and when you take it, you've now taken a gift. And to attach some revocability is not supported in law.
So
that
can
was
a
a response in DeChico and other states that had cases like DeChico saying, we passed these heart bomb statutes, so women can't go around suing these men for their, lost affection, whatever, but now the guys can't get the rings back.
Can the guy get the ring back if he says, here, I want you to wear this? I want you to wear this in anticipation of our marriage.
Right. I think that is more like a trust. If you want to hold this in trust for me, right? And this sort of goes back to the wedding band with his initials on it, right? It was understood you're going to hold this, and then at the wedding you're going to give it back to me. It's hold this in trust for me. A ring is, I think in our society, I think in the case, is I'm giving you the gift. Otherwise, to say it's a conditional gift to me actually sort of cheapens it. Right? I'm giving you this, but I'm not really giving it to you. It hasn't been transferred. The value hasn't been transferred.
But is that, I get it, but is that the rule? Is that the majority? The majority rule seems to be the opposite. It's not treated as an inter vivos gift.
More states than not have kept the conditional gift rule. Albinger in Montana, the court, and I recognize it's described as being an outlier, it is the only state that has done it, but it's not just dicta. They go through all the history of the heart bomb acts, all the history of conditional gift law. It is like Massachusetts and not distinguishable because Montana, like Massachusetts, doesn't have conditional gift. It was invented for this purpose. And it's incredibly well-reasoned. And there are other cases that have...
I'm still struggling with what does that mean for this case? What does that mean for this case? This case is DeChico, right?
I think DeChico needs to be either, if it's held, then I think that Judge Glennie got it right on the facts and found he was not without fault. And if the court says DeChico is antiquated and we need a new rule, The new rule should be the standard, which is a gift is a gift. And again, to the point in Albinger, the Cooper case in Ohio didn't ultimately go that way, but in the decision, they agree that it's a very sensible way to go.
If I could, before I lose you, just because I wanted an answer to this because of DeChico. So the justification analysis, one of the things that DeChico talks about, if it is the law that when Mr. Johnson gave this ring to Ms. Settino, DeChico was the state of the law. So please indulge me that's what we're talking about. So now we're talking about whether or not there was clearly erroneous on the fault analysis. DeChico talks about how at root this is an unjust enrichment case. And they say that specifically. It's about unjust enrichment. So if we're talking about unjust enrichment, how is it that we can do that without actually doing a justification analysis to see whether or not the person is going to be unjustly enriched because their behavior leading to whatever it was that caused you to finally pull the lever is part and parcel to the fault analysis? And in that respect, isn't there some measure here that the trial judge just didn't really evaluate all of that and just really distilled it all to, you saw these text messages, you were wrong, you pulled the trigger because you were wrong factually about whether she was having an affair, so you lose.
But back to the discussion we had earlier, I think, isn't that essentially doing the equity, justification, unjust enrichment discussion?
I don't know that it is, because it seems like I said, it boils down to this is axiomatically why you lose, because you were wrong, and therefore you're at fault for calling it off because you were wrong.
And he found neither party otherwise was thinking to call it off, that Settino wanted to stay in this. So I think implicit in that is she's not unjustly enriched because she was willing to stay. She was willing to stick around. And he actually otherwise was okay, even with the fights they had, but for this misconception. So in terms of the unjust enrichment, she's not unjustly enriched because she would have stayed. She would have stuck it out had he just,
Stuck it out sounds like a romantic marriage. Stuck it out.
So you had
15 years, I'm
started,
thinking about it.
you had started oral argument by saying that there are 3 reasons. I got down 2. The reading a condition where it doesn't exist, the Hartbaum Act itself, and
we thank you for keeping me organized. The other one is this notion of the conditional gift, right? There's the implication, reading the implication into the gift. There's the Hartbaum Act, but there's also, I think we did cover in bits and pieces, this fabrication of the conditional gift idea. That it's just something that's
the
DeChico
default
invented.
is inter vivos,
Right.
and
That a
we've
gift is-
carved out for engagement rings, this conditional gift idea that previously did not exist.
Right, and
Okay.
that for 2 reasons. One is that it was created stemming from this highly gendered expectation to get around Tebow and the Hartbaum Act, but also just because it's inconsistent with Massachusetts gift law. It just doesn't. It was created out of whole cloth.
Okay.